Thank you. Aloha. It is wonderful to see you all, and as an old professor teaching in these large lecture halls, I want to remind people that you can move closer to the front. There is nothing that's going to hurt you down here. In fact, you will feel the emanating warmth and wisdom the closer to the podium you are. That's how it works, right? Students, you know this, right? The closer to the podium you are, the better grade you get. No. I have the great fortune of serving as dean of this wonderful law school. My name is Camille Nelson, and it is a great pleasure to join you this evening as we continue the vibrant new tradition of the Avi Soifer Lecture series. This series serves as a dynamic tribute to Professor Avi Soifer's legacy as a constitutional law scholar, beloved teacher, and long-serving dean whose leadership and service shaped the lives of generations of students and colleagues in the legal profession and beyond. I want to begin by sincerely thanking Reed Hundt, his wife, Dr. Elizabeth Katz, and the Hundt Family Foundation. Their generous support and vision made the Soifer Lecture series possible. Mr. Hunt's long-standing friendship with Avi and their shared concern for the health and future of our legal institutions are woven into the very fabric of this lecture series. I also extend my heartfelt gratitude, our heartfelt gratitude, to Richard Tedlow and his wife, Donna Stanton, for their support. And I understand from Richard that he, Reed, and Avi were all making good trouble in law school together. Is that correct? No tales?
No, Yale 69.
Yale 69, college. Even more trouble, because we know that law students are always well-behaved and make no trouble. So we're grateful to each of you for your commitment to fostering thoughtful discussions on law, on justice, and society, which help our community and the wider public address the most pressing questions about the role and the rule of law in this challenging era. Together, these donors have built a platform that honors Avi's example and inspires us to imagine how lawyers and non-lawyers alike can better serve democracy, the rule of law, and human dignity, encouraging us all to work towards this goal together. It is especially fitting that this evening's keynote is delivered by Professor Risa Goluboff, former dean of the University of Virginia School of Law and one of the nation's leading legal historians. Now, I had the good fortune to introduce Risa on another occasion late last year, and I shared that after just doing all this wonderful research online. There's wonderful, wonderful speeches and accolades about Risa online. I shared that as the 12th dean and the first woman dean of the University of Virginia School of Law. Risa led with purpose, raised the work of social justice and public service, and gave the community, to quote one of her students who was quoted online as saying, a downright deep experience when she taught and led. And Risa, amplifying that wise compassion, made the law school an even better version of itself, which was her aim and aspiration when she started in her service and role as dean. Professor Goluboff's scholarship and work have illuminated the histories of civil rights, constitutional law, and the lived experience of inequality. She exemplifies the intellectual rigor and public-minded engagement that this lecture series seeks to elevate. Professor Goluboff's scholarship and leadership have inspired countless lawyers and citizens to see law not as an abstraction, but as a series of choices that shape real lives and real communities. By inviting Risa to deliver the Soifer Lecture, we celebrate that work and reaffirm this law school's commitment to engaging with our past to create a more just future. So on behalf of the Richardson Law community, I want to thank all of our donors, all of our friends, all of our supporters for your generosity and for your faith in this institution. And to Professor Goluboff, thank you for joining us, and thank you to her wonderful husband, Rich Schrader, who is an eminent law professor in his own right. I thank you for making this trip and for sharing of yourself so warmly and generously. Thank you for what you will bestow upon our students, Risa, our faculty, our alumni, and our friends, and thank you for your help in carrying forward the spirit of inquiry and service that define Avi's wonderful legacy. I know, Risa, that this will be a downright deep experience for all of us. So please join me in welcoming Risa, and I'm going to hand it over to Reed, who will say a few words. Thank you all.
Aloha. As I was this morning swimming in a Scion Sea, looking at above me a robin's egg blue sky and warmed by a peaceable sun, I thought to myself, we live in an age of miracles. So close in the future that we can almost touch it, we will have vaccines that will keep us from getting cancer. We will have drugs that virtually extinguish heart disease. We have, the first test will be next year, of fusion power that will everywhere in the world provide cheap, clean electricity at a marginal cost of zero. Everywhere in the world, the fuel is seawater. And all we have to do is at the same time keep ourselves from tearing our own societies apart. All we have to do is find a way to refound America on sound constitutional principles. All we have to do is rebuild a rule of law so that all of these amazing miracles can not just be shared by everyone in the world, but can allow the flourishing of human capacity for everyone in the world. And that's why we're here. In the second installment of the annual Soifer Lectures, everything I just told you comes to me from conversations that I had with Avi over the years, going back a long time, always focused on how we can change the world for the better. And one of the great things that Avi did very specifically was persuade Risa to come and talk to us today. So without further ado, I'm going to hand the podium over to Avi, who will perform the last of this elaborate introduction. Thank you.
I have been exceptionally fortunate in my life. And that's true because I persuaded Marlene to join me a long time ago. It's true because of our kids. It's true because of friends and because of colleagues and staff and students in particular. I was also fortunate to run on a ticket with Reed Hundt to run the Yale Daily News. And what was really lucky about that was we lost. And kind of as a consolation prize, the Yale Daily News allowed me to start a regional college newspaper, a magazine to insert. Through that came a network of terrific editors, many of them women. Through that came an effort to try to induce Yale to admit women, and we had a good time as well. So it's terrific to see all of you. It's wonderful to see friends here, and it is truly a treat for me to have Risa as our speaker. Risa and I have known each other a little over a long time, but getting her here and having a chance to hang out has been just extraordinary. So thank you all for coming. Thank you, Risa, for being our speaker.
It's going to take me a minute to get organized. Thank you all for those really lovely words. Thank you all for being here. Aloha. I have felt so welcomed from the moment we arrived by your amazing and wonderful dean, who I've known in many different circumstances, and it's wonderful to see you in your institution. And thank you, and to Avi and Marlene for the warmest welcome and the occasion for being here, and to Reed and Betsy and Donna and Richard, thank you, and to Ina and everyone else who has made it so easy to get here all across the world and to be here. Thank you. And to all of you, thank you for being here. So if you read the poster, which you may not have read, the topic I'm going to talk about is a little bit different than what I said on the poster. Can you all hear me? Is the mic in a good place? Okay. Just as you go about writing these things, you know, they evolve. So what I'm calling this lecture now is Law and Disorder: Meditations on Charlottesville 2017. And as Avi and Reed have explained to me, one of the inspirations for this lecture series was a speech that 28-year-old Abraham Lincoln gave in the winter of 1838 to the Young Men's Lyceum of Springfield, Illinois, a speech that really continues to resonate in many different ways almost 100 years later. And they asked me to use that speech as a jumping off point that might help us generate new insights today from my vantage point as a legal historian and a civil rights and constitutional law scholar, and I'll throw in former dean for good measure. As you heard in the introduction, I am from Charlottesville, Virginia, and Lincoln's Lyceum speech prompted me to think new thoughts about the white supremacist violence there in 2017 and what it tells us about the role of law and the rule of law. At the crux of the speech were Lincoln's worries about what he called the perpetuation of our political institutions in light of several recent incidents of both private and state-assisted mob violence on the eve of the Civil War. These were likely three events that had happened: the lynching of a group of professional gamblers in Vicksburg in 1835, and boy, Lincoln did not have nice words about gamblers. A second lynching of a free black man in St. Louis, and the killing of a prominent abolitionist and newspaper editor. None of the perpetrators of these incidents of mob violence faced legal consequences, and in one instance, the defenders of the victim even found themselves criminally prosecuted, though they were ultimately acquitted. Lincoln condemned what he saw as, quote, an increasing disregard for law which pervades the country, the wild and furious passions and mobocratic spirit that he worried would lead law-abiding citizens to turn to such violence themselves. And he predicted that people would become tired of and disgusted with, that's a quote, a government that offers them no protection, and the rule of law on which the nation was founded would hence collapse. So Lincoln called for, quote, every American never to violate in the least particular the laws of the country, and never to tolerate their violation by others. He called for, quote, veneration and reverence for the Constitution and laws to be inculcated in and learned by all. And though he lamented the absence of legal consequences for participants in the mob violence, he didn't actually call for increased law enforcement. He didn't call for more effective legal remedies or swifter punishment for the lawless. What he called for was a change in attitude of the people. Perhaps this was because he knew, or maybe he worried, that at the time in the early 19th century, the kind of monopoly on violence that would have been required of an American government was not quite in place yet. The government was not capable of that yet. Or perhaps it was because the Young Men's Lyceum, this was a group of the pillars of the community, young white men, professionals, and maybe he thought, I'm offering them a solution to this problem that would empower them and inspire them and make them a model for others, as I'm sure it did. And the educator and the higher education leader in me heartily endorse civic education. We live in a time when too few people know or understand our Constitution and our structures of government, and when such knowledge is more important than ever. But the lawyer and the legal scholar in me and the historian in me was struck by the non-legal solution for what this 19th century lawyer identified as a fundamentally legal problem. And I wondered why Lincoln's preoccupation with mob violence and its lack of legal redress did not move him to speak more about the law itself. And trying to understand the role of law in mob violence has been a preoccupation of mine since, I would say, August 11th and 12th, 2017, when white supremacists and neo-Nazis, whom I will collectively call white supremacists in this lecture for reasons I'll share with you in a bit, marched with burning tiki torches across UVA's campus, surrounding and trapping counter-protesters around a statue of Thomas Jefferson, and then the following day swarmed downtown Charlottesville to protest the planned removal of 2 Confederate statues, leading to pervasive violence and injuries, the murder of 1 counter-protester, and the deaths of 2 law enforcement officers in a helicopter accident. At that time, I had been living in Charlottesville with my family for around 15 years. I was an active member in my local synagogue and a faculty member at UVA, and I had been dean of the law school for all of a year. I led my law school community through those days and their aftermath, and I also chaired the committee that led the university's response as a whole over the 2017-2018 academic year. And I first started thinking about the relationship between law and mob violence as part of, Lincoln calls it mob violence, I would call it disorder. There are many words we could use, but I first started thinking about it as part of my role in coordinating the university's response and an evaluation that my committee undertook in the days right after August 11th and 12th happened, thinking about assessing the university's police response. And I have been thinking about it in one way or another ever since. So given that, I was really struck by the way Lincoln sets law and mob violence as dichotomous. Law exists on one side, mob rule on the other. Or, in another way of putting it, law should act and function to prevent or at least redress mob violence. Clearly, that is all true, but it doesn't go far enough. It isn't to say that mob violence exists within an absence of law. And in fact, what I have discovered in a book that I'm writing on the subject and through which this lecture is a part, is that law simultaneously structures such violence in advance, facilitates its own deployment during disorder, and then responds afterward. Law is there, in other words, at the beginning, in the middle, and at the end. It is ever present. And even law's absence is a presence in the choice of law not to intervene, not to prevent, or not to redress. And in some cases, violence is even a collaboration between those tasked with enforcing law and those intent on its violation. This might seem an odd claim, given that much of what made Charlottesville a national and even a global event was what appeared to be a serious absence of law during those 2 days. But the rest of this lecture will elucidate this thesis, that law is ever present in the context of the violence that happened in Charlottesville in the summer of 2017. I will start with how law shapes what happens before violence and disorder occur by making certain legal categories, rhetoric, and logic available to the various actors. It then facilitates what happens during such incidents of disorder through the deployment of those legal categories, the responses of law enforcement, and the invocation of the mechanisms of legal process. And then finally, it operates afterwards to distribute consequences and attempt to repair its own breach. So part one. There are going to be many parts. I'm going to lead you through. You can raise your hand if you lost the thread, but I don't think you will. Okay, part one, the background legal conditions for disorder. You can think of the before as what legal historians and law and society scholars call the constitutive or facilitative nature of the law, the idea that we can only see the world through legal categories. And here you can think of marriage, right? Once you are married, you are in a different legal category. When you say, I'm married, I am a wife, that's a legal statement that you're making. It has to do with your duties and your responsibilities to another person. And though Lincoln doesn't discuss this, you can see law structuring the incidents that prompted his speech. The gamblers were lynched when they refused to leave Vicksburg after a new law required their expulsion, and the military went door to door seeking out gamblers. The lynched abolitionist tried and failed to get its city council to protect the freedom of the press before he was then lynched. And you can see similar things in Charlottesville. So before I tell you the various background legal conditions, I want to give you 3 caveats for these conditions. So first, there are stronger and weaker versions of this claim. Stronger, more causal versions, weaker ones that are just reflective of the logic that one would see. And I'll tell you where I see the stronger and weaker versions as I go through. Second, my point is not to criticize or celebrate any of these particular background legal norms or doctrines. Some I think are good, some I think are not good. You may disagree with me, but my point is to show the consequences of what these legal doctrines are. And third, I remain agnostic on whether these consequences are intended or unintended from those legal doctrines. So you can make up your own mind about those. So legal frameworks in 3 different areas of the law set the conditions for, or articulate the logic for, or facilitate, right, different levels of strength or weakness, non-legal ideas about what happened in Charlottesville in 2017. And these 3 areas are anti-discrimination doctrine, free speech doctrine, and Second Amendment or gun regulation doctrine. So I'm going to go through each of those, and they're each going to have some subparts. So, okay. So first, anti-discrimination doctrine. Anti-discrimination law facilitated, or in my view, at least validated or made possible certain ideas about race and religion that surfaced on August 11th and 12th in 3 ways. The first is with regard to racial equality. So the headline about racial equality after August 11th and 12th was one of surprise, mostly by whites, by many whites, that such blatant forms of white supremacy still persisted in 2017. And that, again, is true, but not the whole story. Because what's important for what I'm trying to lay out here is the form that anti-discrimination law has taken over the past 70 years, which structures and creates new logical and rhetorical resources that the white supremacists used in their self-presentation. Whereas many of them identified openly as white supremacists, others intentionally called themselves advocates for white civil rights, or white advocates. And that term was made possible, or at least validated by, the dominance of what we call in constitutional law the colorblindness or anti-discrimination approach to equal protection, which stands in opposition to the anti-subordination approach to equal protection. This dominant approach has treated most race-based governmental action as constitutionally equivalent. So Jim Crow is the same as affirmative action under this approach to equal protection law. It insists on an aggressive neutrality across all racial advocacy. Black civil rights and white civil rights are the same thing. And wittingly or not, this doctrine has facilitated white victimhood and white racial grievance, and it lent rhetorical, intellectual, and constitutional heft to the position of the white advocate on the eve of 2017. The second aspect of anti-discrimination doctrine that's relevant here is the fact that the racism on display in Charlottesville in 2017 blended anti-Black racism with religious and anti-Semitic rhetoric. The impetus for the rally, as I mentioned, was the city of Charlottesville's decision to remove its statues of Confederate heroes, but that anti-Black racism was intertwined with white Christian nationalism and anti-Semitism, which were highly visible in the images of the white supremacists waving Confederate flags and swastika flags together, and the prominent chants of "Jews shall not replace us." Anti-discrimination law's relationship to both religion generally and anti-Semitism specifically is thus equally relevant to the background legal conditions and our understanding of them. So first I'll talk about religion, and then I'll talk about anti-Semitism. So with regard to religion, over the past several decades, there have been a lot of changes in the way the Supreme Court treats religion doctrine, and in particular, the Establishment Clause, that mirror the equal protection developments that I just mentioned. So in the past, until these recent developments, the Establishment Clause was thought to prevent governments from funding religious entities as part of the command not to establish religion, right? The First Amendment says that Congress shall not establish a religion. But over the past few decades, religious majorities have borrowed the language of anti-discrimination from race discrimination, prompting the Supreme Court to shift its Establishment Clause doctrine toward an aggressive formal neutrality analogous to the race context. So now, governmental non-funding of religion, which used to be required by the Constitution, has been recast as discrimination against religious people. And as in the racial equality context, the doctrine's aggressive neutrality as between minorities and majorities licenses a sense of victimhood that together with colorblindness enables the kind of white Christian grievance that includes the explicit fear of the destruction of white Christian civilization that we saw in 2017. So you've got anti-discrimination law in terms of racial equality, you've got Establishment Clause in terms of religion, and the third and final aspect of anti-discrimination law is the law's relationship to anti-Semitism. So there are some civil rights laws in the United States, including most notably Title VII, the employment discrimination law of the 1964 Civil Rights Act, that include prohibitions on discrimination against religion. But others don't talk about religion. They only prohibit discrimination on the basis of race, color, national origin. But over the past 40 years, Jews, as well as other groups that are viewed as both religious and ethnic or racial minorities, like Muslims or Sikhs, have come to receive protection under racial anti-discrimination laws, even when religion itself is not protected. The justification for this comes from the Civil Rights Act of 1866, about which Avi is an expert, which guarantees all citizens the same rights as white citizens to make contracts and hold property. So the question the Supreme Court asks in deciding whether this law applies to any particular group is, were they perceived as white in the mid-19th century? And Jews were not perceived as white in the mid-19th century. And so it has been determined that they can receive protection under this 1866 civil rights law, and that has now been extended to other civil rights laws as well. And there are clearly tricky contradictions here. Many Jews think of themselves as white, and they are treated as white by many laws and in many contexts, but certain civil rights protections are only available by mirroring long-standing racialized versions of anti-Semitism, like those on display in 2017. So the logic of the law not only offered justification for white Christian nationalism itself, but also extended the reach of their racialized ideology from Black Americans to Jews. And that is why when I say white supremacists, and I don't feel the need to say at every turn, white supremacists and neo-Nazis and neo-Confederates, it's all racialized. It is all racialized. So both those advocating anti-Black and those advocating anti-Semitic views are, in my view, white supremacists. So I can use just that one phrase, which also makes it easier to say. Taken together, these three anti-discrimination frameworks created rhetorical and analytical space for a simultaneous sense of white victimhood and a race-based attack linking the alleged racial inferiority and impurity of Black Americans and Jews in what they saw as a quest for their own destruction and replacement. Okay, so that's our first background condition, is anti-discrimination law, race, religion, anti-Semitism. So now we're on our second background legal condition, which is speech. First Amendment. I have a stronger version of the argument here. I think this is my strongest version of the argument. It's the first one I saw when I was thinking about this question. And that is that the background conditions of free speech doctrine really fundamentally shape everything that happens on August 11th and 12th. And there are 3 background conditions. It won't always be 3. Once it's going to be 5, so get ready. There are 3 background conditions that I have in mind. The first is that peaceful protest is protected constitutionally and categorically distinct from conduct, and in particular from violent conduct. The second is that counter-protesters, those who come to protest the protesters, cannot be allowed to drown out the speech of the protesters. And the third is that hate speech is constitutionally protected despite the common perception that it is not. And both halves of that are important for my background frameworks. Okay, so free speech doctrine is famously messy, but however messy it is, it was clear in 2017 that in public forums, expression must be allowed within certain content-neutral constraints, time, place, and manner constraints, and that speakers who engage in such protest, who are often described as peaceful protesters, are deserving of First Amendment protection, and they receive the imprimatur of the law. In the context of August 11th and 12th, the dominant image for this legal framing was an event that never actually took place, but has had a big role in the legal imagination of free speech. And that's the image of Nazis with the flags, Heil Hitler, marching peacefully, that's what they were saying, not what I'm saying, marching peacefully, if you can call that peacefully, because you might think that is inherently violent, but marching compliant with the rules in Skokie, Illinois in 1977. Even though that march never happened, the image of that march did enormous work in shaping what many actors saw in anticipation of August 11th and 12th, what the university saw, the city, the courts, the lawyers, and the various police forces. The white supremacists presented themselves as unpopular but protected peaceful speakers. And all of those key actors accepted the white supremacists' self-presentation at face value, even when faced with ample evidence, and I'll come back to that in a minute, that in fact the white supremacists intended to do and incite violence and disorder. With the white supremacists occupying the role of protected speakers, the only role available to the anti-racist activists who had made clear that they planned to confront the white supremacists was that of the potential heckler. That's what the free speech doctrine calls them, and they may not enforce what is called the heckler's veto. They may not suppress the speech of the primary speaker. They may not stop them. They may not shout them down, and they may especially not do them physical violence. And as a result of this idea that the counter-protesters were possible hecklers, they were seen as the primary threats to order. Not the white supremacists, but the anti-racist activists. Okay, so add to these 2 aspects of the free speech framework. One, that there's a clear distinction between speech and violence, and that these were self-proclaimed protected speakers, and they were not expected to do violence. And 2, that there were only 2 roles, the speakers and the hecklers. And that if you weren't the speaker, then you were a heckler, and you had to be prevented from becoming a potentially violent heckler. So in addition to those 2 aspects was the third, which was that both sets of speakers perceived themselves to have an entitlement to speak. So the First Amendment protects even what we would call hate speech, right? It is protected. Hate speech is protected. Not hate crimes, not when the speech is connected with conduct, as we've been talking about, but hate speech. And that clearly applied to much of the white supremacist rhetoric. But the public perception was, and remains, and there are surveys about this, that hate speech is unprotected by the First Amendment. Now, you might say, but that's not law structuring what happened. If it's not the law that hate speech is protected, is unprotected, but it is the not law structuring what happened. And this is important. The United States is an outlier in the world in protecting hate speech. So lots of people familiar with other regimes think it must be unprotected. And moreover, there are real tensions between anti-discrimination law and free speech law that have led people to think that hate speech might not be protected. And what this meant was that each side thought that they had an entitlement. The white supremacists thought they had entitlement to speak hate, which they did, but the counter-protesters thought they had an entitlement not to hear hate, which they did not. But that did not affect the fact that they felt that entitlement. And this was a recipe for more confrontation and more possible violence. Ultimately, as we will see when I get to the during in a minute, these various aspects of free speech doctrine go a long way toward explaining why and how unmediated violence between the protesters and the counter-protesters occurred. Okay, so anti-discrimination, free speech. Third is the Second Amendment, guns. So the law can also shape events by what it hasn't decided, by the gaps in what it decrees, by the doctrines it has put into motion but hasn't yet answered all the questions about. And this was the case with Second Amendment doctrine at the time of the Charlottesville violence in the summer of 2017. So 9 years earlier, in 2008, the Supreme Court had transformed the law of gun regulation. It had held for the first time that the right to bear arms was an individual right to self-defense as well as a collective right to participate in a militia. But between 2008 and 2017, the court had said very little except that the states, as well as the federal government, could not violate people's Second Amendment rights. So they opened up this new series of rights, and then they said very little about it. And gun rights advocates immediately treated these cases as creating wholesale gun rights to do anything, anywhere. And the court had not yet weighed in to say, well, maybe that's not the case. Maybe it will never weigh in to say that. But it hadn't at the time. And in some 1,100 cases between 2008 and 2016, lower courts heard challenges to gun regulations about public carry, about carrying your guns in public, and the litigants succeeded about half the time. So that means that whether a court was going to protect the right to public carry was as clear as the outcome would be from tossing a coin. The resulting doctrinal landscape was one in which the most basic questions about gun rights were unanswered, they were open, they were confusing, they were inconsistent. And this meant that for the white supremacists who came to Charlottesville in 2017, there was no settled law to which they might conform their weapon-carrying conduct, even if they were so inclined. And this uncertainty was compounded yet further by fundamental and unanswered questions about the relationship between the First Amendment, free speech, and the Second Amendment, gun rights. One might have a First Amendment right to carry arms at a protest as part of your free expression. And one might have a Second Amendment right to open carry at a protest. These questions were unanswered in 2017. The white supremacists, many of whom arrived as part of private militias, felt constitutionally entitled to their open carry and ostentatious display of weaponry. Law enforcement, for their part, were uncertain about the extent to which they could prohibit such weaponry, and they were also worried that they didn't actually have the manpower or resources to do so. Okay, so in part one, I talked to you about the before, all of the ways in which the law created the background conditions under which violence and disorder might happen. So part two is the during, and there are two parts to the during. One is going to be a lot longer than the second. The first part of the during is how we see these legal categories deployed by different actors when the disorder is happening. And then the second category, so I think of that as the facilitative aspect of the law. This is how it gets facilitated during. And the second is law as a tool. So it's not only that law is implicated in mob violence because it creates the conditions, it's also that participants strategically deploy the law. Legal frameworks don't actually do things. their legal frameworks, right? It takes people to give them power, people who are sophisticated about these structures and these narratives and these rhetorical resources. And the white supremacists were highly sophisticated in this regard. And I'll give you a few examples. So one, in May of 2017, several white supremacists held a torch rally that served as one of the precursors to what happened in August. So the summer was called the Summer of Hate because there were actually multiple events that happened. A KKK rally in July, this torch rally in May, leading up to what happened in August. And at that event, though they chanted anti-Semitic tropes like blood and soil, they stood up and said, "We are not white supremacists. We are white advocates, not white supremacists." And they describe themselves, again, they are articulating how they want you to see them. They described themselves as engaged in peaceful demonstration. To give you another example, they called their August 11th and 12th rally the Unite the Right rally, explicitly placing themselves within the tradition of political speech, not racist or anti-Semitic speech. They position themselves as a conservative political coalition peacefully protesting the Charlottesville City Council's decision to remove Confederate statues. These were diversionary tactics. As a federal court later concluded, peaceful speech was never their plan. Their plan was both to incite and do violence by positioning themselves as constitutionally protected victims. According to one legal expert, they strategically created distance between their public face of peaceful protest and their private plans to incite and engage in violence. They said that maintaining plausible deniability would, quote, shield them from being blamed for wrongdoing, including criminal conduct. The Daily Stormer Guide on the internet, one of their guides, said, quote, "It's illegal to promote violence on the internet. At the same time, it's totally important to normalize the acceptance of violence as an eventuality or an inevitability." So they positioned themselves as free speakers in order to incite a reaction from counter-protesters that would justify their own violent response. This was their plan from the beginning, and their plan was utterly successful. The white supremacists retained the ACLU of Virginia to defend them against a lawsuit by the city of Charlottesville. What better evidence to reflect and reinforce that they were free speakers deserving of legal protection than the ACLU as their lawyers? The police also accepted their self-presentation and clearly saw their role during the spring and summer of 2017 as ensuring that the counter-protesters would not prevent the white supremacists from speaking. The Charlottesville Police Department included a First Amendment refresher in its advanced planning for a Ku Klux Klan event on July 8th. Its operating plan focused on providing, quote, "the Klan with safe passage to their designated area while maintaining separation from counter-protesters at all times," close quote. And after they did provide that safe passage, police in riot gear released tear gas and arrested 19 counter-protesters. The counter-protesters tried to fight this narrative at every turn. Sometimes they rejected the speech violence distinction, contesting the legal protection of hate speech. At other times, they accepted that distinction, but tried to shift the white supremacists from the category of free speakers into the category of committers, or at least intentional provokers of violence. On the flip side, they tried to shift to themselves, or at least to share, the free speech mantle by highlighting the peaceful nature of their protests, for example, by centering the clergy in those protests. These efforts were hampered by mutual mistrust between the police and the counter-protesters. That stemmed in part from the Black Lives Matter movement and its systematic critique of police violence against minority and especially Black communities, and in part from Antifa and the right stoking of police fears of Antifa. But all of that said, at the end of the day, the counter-protesters' fears of violence by the white supremacists ultimately overcame their mistrust of the police. and community members whose intelligence gathering before the events was in many respects far superior to that of state and local law enforcement entities, tried to inform the university and law enforcement about their knowledge of the white supremacist plans for violence. The police rebuffed and ignored their efforts. Out of some combination of police sympathy for the views of the white supremacists or even potential collaboration with them, as some anti-racist activists claimed, the First Amendment framing I've been discussing and consequent police assumptions about the intentions of the counter-protesters, a lack of sufficient resources, or sheer incompetence. As August 11th and 12th approached, one of the organizers of the march was named Jason Kessler, and the UVA police chief stated that he, quote, considered Jason Kessler's march like any other political event on grounds. The university's public areas were fair game for any ideology, and the university police department would only intervene if laws were broken. The Charlottesville Police Department also did not prepare to prevent violence. They expected violence to occur, and their plan was to restore order after the violence occurred. Police witnesses recall the Charlottesville police chief saying, as the brawling first broke out, quote, let them fight. It will make it easier to declare an unlawful assembly. To the extent that they expected laws to be broken, they thought that the counter-protesters would be the ones to break them. One Department of Homeland Security analyst predicted that anarchist extremists were the likeliest to commit violence and that the lawfully permitted white supremacist preparations to counterattack anarchist extremists would be justified as self-defense. It is particularly striking that this attitude remained the case even after the white supremacists arrived heavily armed, with many participating in militias. According to then Governor Terry McAuliffe, quote, 80% of the people here had semi-automatic weapons. You saw the militia walking down the street, you would have thought they were an army. They had better equipment than our state police had. Despite the overwhelming display of white supremacist weaponry, the Charlottesville police maintained its plan for officers to wear soft uniforms, usually intended to express, quote, both a commitment to support free expression and a recognition that most participants are peaceful. And they stored their riot gear off-site for use, if necessary, at a later point. The point here is not that the white supremacists were not engaged in expression. They were engaged in expression, or that their weapons might not have been legally protected. They might have been. But it is that they used these background legal frameworks and narratives to mask their violent intentions. And when the police finally acted, the first arrests, as planned for by the white supremacists and predicted by law enforcement, were of counter-protesters. The violence that ensued, in other words, was the result of the white supremacists' successful deployment of these various background legal rules, the inability of the counter-protesters to undermine that deployment, and the deliberate exclusion of the state's monopoly on violence and ability to function as a mediating force in private conflict. It was not until far too late, after death and violence and injury had ensued, that the white supremacist strategic deployment of these background legal rules became apparent to law enforcement and others, as it had long been apparent to the counter-protesters themselves. And the belatedness of that realization played a major role in my committee's report about the university's law enforcement response to these events. When President Trump declared afterwards that there were, quote, good people on both sides, he utterly vindicated the white supremacist strategy. Likely without even realizing it, he encapsulated the aggressive neutrality of American constitutional law that had been the cornerstone of the white supremacist approach. Neutrality as between black civil rights and white supremacy. Neutrality as between discrimination against religious minorities and religious majorities, as between speakers and counter-speakers, as between the First Amendment expression of clergy in their religious garb and white supremacists brandishing weapons, as between the information, the good information offered by black Americans and their allies of whom the police were skeptical, and the deliberately misleading information provided by white supremacists that the police accepted at face value. But it was not only that, and here is where the second type of legal jockeying comes in during. So the facilitative was the first, how they deployed these background legal rules. But the second is the legal process itself serves as a tool for the during, regardless of the substantive legal rules. And this is using the legal process as a tool of power to call the police, to get a warrant, to file a complaint, to threaten a lawsuit. And these potential legal interventions pervade our interactions with another, and they serve as instruments of harassment, of intimidation, of incapacitation, and always of the threat of any of those things. So this use of law as a tool functioned across the interactions between these various groups and many of their adherents before, during, and after August 11th and 12th. It was pervasive. You see it in scuffles around the Confederate statues, in restaurants, on our downtown mall, not only in moments of extremis, of real violence, but in mundane moments for 6 months before and many months after August 11th and 12th. Activists on all sides deployed the law as a tool regularly and strategically. So here's a really mundane example that I think is very telling. At an earlier political rally, Jason Kessler, one of the organizers, was trying to live stream on his phone. And while he was doing that, the live streaming on the phone itself a kind of threat of future action, either legal or extra legal, a woman, an anti-racist activist, took his phone out of his hand. And then a man took the phone out of her hands. And what might in other contexts have been sort of like grabbing at the phone led to separate criminal prosecutions of both the man and the woman, right? They went and filed criminal complaints about this mundane interaction, and that happened all the time in the months leading up to August 11th and 12th. Now, there might seem to be some tension between my original description of the legal availability of law everywhere, this description of law everywhere, with my earlier description of the white supremacist efforts to keep the law out, right, during the actual disorder, but both were simultaneously true. Law was both everywhere and nowhere. The various actors both flaunted the law and clothed themselves in the law. They tested and manipulated the law's monopoly on violence, especially in the form of the police, right? The police who are meant to stop that violence. The white supremacists wanted the law out so that they could engage in violence, but they wanted it in to protect themselves and to threaten legal action via arrest and potential future lawsuits. So this was disorder, but it was legally inflected disorder. It was not anarchy. Okay, so the before, the legal backgrounds, the during, those legal backgrounds facilitate their deployment during and also legal processes more generally, and then the after. Can law repair its breach? So none of this, the before and the during, is to say that the law can be structured to prevent all breaches or all disorder. Whatever the law does, whatever it is, will create background conditions and resources for various actors to deploy. But it is crucial to understand what are those background conditions in a given instance. They illuminate important aspects of our laws that we might not otherwise see and that we actually might want to change. It's also not to say that Lincoln was wrong about the potentially salutary effects of law on mob violence. A legal response calling participants to account, to do justice, to repair breaches in the rule of law, and to prevent future breaches is, of course, crucially important. This was, in fact, the first question that I asked myself. Can or how does the law repair breaches? And I remember distinctly the first time I thought systematically about this in the context of the Charlottesville violence. I was at a holiday party in December of 2018, a UVA Law alumni holiday party, and I struck up a conversation with a local judge who was an alum, and he told me that he had 13 distinct cases on his docket relating to August 11th and 12th, 2017, and it made me wonder how many other cases there were and what kinds they were: federal, state, civil, civil, criminal. And that conversation is what prompted this book project. So I began to identify and amass records for as many cases as I could. I have now cataloged 136 cases, from which we can see how different individuals, organizations, social movement actors, government entities mobilized legal actions and claims, not only in reaction to these events, but before and during. So I've tried to figure out, what does repair look like? So I have 5 thoughts to share with you, and this is my last section. I have 5 thoughts, and they're not as long as the other ones. I have 5 thoughts to share with you about what I can already see in these after cases. First is how we need to shift our time horizon of the legal response to disorder. Second is how we can see in these cases the imprint of those deployed legal frameworks. Third is what a wide variety of legal mechanisms have come to be brought to bear. Fourth are the limitations of the law's responses. And fifth is the invisibility of some of the responses that we can't even really see in the record. Okay, so first, what seemed like an event that took place over 2 days actually started 6 months earlier and lasted for another 1.5 years. And a quarter of the cases are before, half of the cases are during, and a quarter of the cases are after. There's a very nice kind of bell curve there. And they began with harassment. They began with these street scuffles, with people spitting at each other and throwing things at each other and taking each other's phones, and then bringing the law in for prosecutions as well as civil complaints. And you see the same names come up again and again. These are ongoing relationships where people are having conflict on the street and then bringing the law in to that conflict on the street. And then after that, there are the arrests in May and July at these precursor events, the arrests in August 11th and 12th, and then arrests afterward, including, I'll talk a minute about arrests of counter-protesters during a press conference that Jason Kessler held the next day, as well as arrests of counter-protesters during a city council meeting a week later when they accused the city council of having blood on its hands. The arrests continued for another 2 years. And throughout, there are claims and counterclaims by parties on both sides of the conflict, multiple cases around a single otherwise inconsequential interaction, each appealing to law to put its force behind their claim. The legal record makes clear the extensive role the law played in disorder that seemed to occur discreetly. It also shows that while I've created these before, during, and after categories, they're too simple. They're a construct. The before becomes the during, which becomes the after to a new before. And so this is a dynamic and ever-shifting process in which law's many roles overlap and they conflict and they reinforce one another. Okay. Second, we can see in these cases the imprint of those background legal doctrines and then their deployment in the during. The pattern of the arrests owes so much to those narratives. The fact that it was only counter-protesters arrested on July 8th, that it was counter-protesters first arrested on August 12th. The pattern of cases confirms this. There are First Amendment cases, many First Amendment cases. There are civil rights claims trying to pull back the free speech mantle and reveal the racist intentions behind what the white supremacists were doing. Some civil rights cases trying to implicate the police in the violence that had happened. And notably, there are multiple state civil suits against the police and other law enforcement agencies for failure to act, police inaction, stand-down orders that were both brought by white supremacists and by counter-protesters. Third, there is an incredibly wide variety of cases that you see in the after and the before. They include those you would expect: charges for assault, traveling interstate with intent to riot, failing to disperse from a riot, using pepper spray, disorderly conduct, lots of low-level and felony criminal laws. But in addition, there are wrongful death suits, defamation suits, FOIA requests, the various cases concerning the Confederate moderates. One even finds a bankruptcy case and a court-martial related to these events. In other words, a full accounting of the legal response goes far beyond state and federal criminal prosecution. The law is not one thing. It is a complex set of interlocking systems available for use by different actors in different ways, and assessing its response requires making it first visible in its totality. Only then can one ask, what has it done? Fourth, that brings me to limitations. It was far more difficult than I anticipated to try to assess the effect of the law on the breach in its fabric. Who won those 136 cases? On whose behalf was the law effectively mobilized? Was the law operating as Lincoln hoped, to provide redress, justice, deterrence from future violence? So there are a few different limitations. The first is an anemic prosecutorial response to this violence. Given the hundreds of people who were involved in the violence on August 11th and 12th, one might expect to see more than 91 state criminal cases across the whole 18 months, and more with white supremacist defendants who only make up a third of the defendants in those 91 cases. There were only 9 federal criminal prosecutions, one against James Fields, the man who drove his car into Heather Heyer and killed her, and 8 under a federal anti-riot act. The Maine Justice Department took no action. There were initially only 3 completed prosecutions stemming from the violence at UVA on the 11th. It took a new Commonwealth's attorney and incredible activism to get the Commonwealth's attorney to take more cases. The second limitation stems from what happened in the cases themselves. There were some instances where the law really seemed to provide redress. There was a state civil suit against the white supremacists that argued that under the Virginia Constitution and statutes, any militia had to be under the authority of the state. And that led to a settlement, a consent decree that made it impossible for armed white supremacists to return to Charlottesville in groups of more than 2. That said, questions remain about whether situations like that in Charlottesville might justify greater government regulation of weapons more generally, and during protests specifically. The ACLU, for its part, announced afterwards that it would no longer defend the right to protest of those carrying weapons. So they changed their view of the relationship between the First Amendment and the Second Amendment. But we haven't seen a lot of learning beyond that. We can perhaps see the law working to rectify harms and prevent further violence in the 3 most high-profile cases that have come out of this. A state jury found James Fields guilty of first-degree murder, and he pled guilty to 29 of 30 counts of federal civil rights prosecution and received 2 life terms in prison for both. The third is Sines v. Kessler, a multi-million-dollar private federal civil rights lawsuit against the white supremacists, and a jury found the defendants liable, 24 defendants, and they awarded an unprecedented $26 million in damages. Despite these victories, it remains unclear how much direct impact they have had. The Sines damages award was later reduced in accordance with state statutes, and 10 years later, an appeal is still pending. It is thus not clear to what extent, even in 2017, when the legal capacity of every level of government far exceeded anything Lincoln might ever have dreamt of, the law has worked to rectify its breach. Beyond the headline cases, the outcomes are even more equivocal. For example, even the question of whether any given defendant or case won or lost is very hard to tell. Cases were continued. Some defendants received only nominal sentences. Others pleaded nolo contendere. It was not clear how we would decide whether someone won or lost their case. And the answers to these questions also depend on the time frame one has in mind. It is possible that the law worked because the Sines litigation served to bankrupt some of these white supremacists and their organizations, leading to their return to the internet from the streets. But it is also possible that the law failed because some experts now think that that shift may have contributed to the increase in lone wolf white supremacist mass shootings since 2017. The answers depend as well on how broadly we think about the law. We have to understand the administrative responses by various institutions, developments in the Charlottesville City Council, Charlottesville politics, state legislative and federal agency responses, and social activism on all sides. The fifth and final limitation of the legal response is the insufficiency of my archive to provide a full picture about the operation of the law, not only because of unclarity in the outcomes that we can see, but also because how we got to these outcomes are often hidden intentionally or unintentionally by the legal records. This is the last thing I'm going to say before I close. So I know this because of my own involvement in one such case. So 2 months after I had that conversation with the judge, on Valentine's Day, 2019, in fact, I was called for jury duty, and I get to the courthouse, and it turns out that I know the defendant. She's a high school teacher who had been my children's summer camp counselor for many years. And during Jason Kessler's press conference, the day after everything happened, she had bear hugged him while yelling, "We love you, Jason," and she pushed him to the ground. She was arrested and charged with assault and battery. She had claimed that she was trying to protect him from violence and aggression of other counter-protesters, but in his view, she had assaulted him. So the judge gave us very few facts about the case, but he did tell us that Kessler was the complaining witness. He wasn't in the courtroom that day, but he was in the courthouse. I later learned about him. And during voir dire, I shared how I both knew the defendant and how I knew Jason Kessler and the role that he had played as primary organizer of what had happened on August 11th and 12th, both as dean and as chair of the university's response. Likewise, many of the other potential jurors shared what they knew of Kessler. One after another, they stood and told their stories. Where they were on August 11th and 12th, the harms they suffered, their views of and feelings about the white supremacists. Twice, the prosecutor unsuccessfully asked the judge to move the voir dire out of the public courtroom and do it privately. Judge said no. He was hoping that there would be some uncontaminated jurors. As the voir dire continued, it seemed increasingly unlikely that an unbiased jury could be seated. And the judge and the lawyers eventually conferred in their chambers. We were removed from the courtroom, then we were brought back to the courtroom, and the judge told us that an agreement had been reached in the case, and he thanked us for our service. The defendant's attorney also thanked us, stating that our presence had resulted in the case being resolved. And I later learned that the defendant had to apologize to Kessler in open court, perform community service, and maintain good behavior for 6 months, after which the case would be dismissed. Who won? Who won that case? It's hard to say. But I can say that the experience of sitting in that courtroom and hearing those testimonials itself seemed an instance of the law working, if not quite in the way we usually mean. It seemed to galvanize the jury pool collectively and perhaps by extension, our whole Charlottesville community. Even as the lawyer in me knows that the law cannot tolerate vigilante justice, the case's equivocal outcome, and even more, the way the voir dire functioned as a cathartic testimonial by these potential jurors, seemed in some ways to reimpose community norms, to allow for community healing, and to effect a kind of rough justice in the face of what seemed to many in the courtroom an unjust charge on behalf of an undeserving complainant. That this moment is lost to the historical record, but for the quirk of my jury duty, tells us something very important. It reminds us of our profound inability to ever fully assess the law's effectiveness. So here we are, an hour after I began, and I can't say whether the law repaired the breach in the rule of law after Charlottesville. Some historians and commentators have concluded yes, or at least that the counter-protesters had won the day. Others not so much. Just as there is no stark dichotomy between law and disorder, so there is no cut and dried answer to when and how the breach has been repaired. What I can say is that, returning to the Lyceum speech, I mean this lecture as reverence for the law, in the sense in which I believe we, as a people, should revere the law by engaging with it. I fear that Lincoln's dichotomy between veneration of the law and mob violence is too brittle. If we are only left with those two poles, what if we reject the former for the latter? Though I am a historian, and I have taken this opportunity, I hope not with disappointment from those of you who created this lecture, to speak about our history rather than our future, it is hard to ignore the fact that we have seen recently new relationships between law enforcement, or government more generally, and mob violence, new intersections between gun rights and protest, new understandings of who free speakers are and what rights they do or do not have. It is hard to ignore the fact that at this moment, a dichotomous choice between mob violence and the law seem to be leading us in the wrong direction. It is my hope that by understanding the rule of law, the role that law plays in the before, the during, and the after, by understanding that the problem is not, as Lincoln suggested, an absence of law, but really recognizing that we are awash in law, it is only then that we can revere the law, and only then that we can choose how to deploy it. Not for mob violence, disorder, and hate, but for justice, order, the rule of law, equality, community, and the veneration of those values we the people aspire to hold most dear. That is how we honor our founding, our foundational documents, Lincoln's prescience, and the health and preservation of our democracy for another 100 and 200 years into the future. Thank you.